and they both serve on the ACBA board. All right, so making sure Pamela feels ready, okay? And is our technology ready? Oh, that's my seat, sorry. All right. Alice and Colin, you want to give us a quick refresher on the roles?
Yes. Hi again, everybody. Thank you for staying for part 2. The rules of this part are the same as for the judicial seat. Each candidate will have 1.5 minutes to give an opening statement, starting with Ms. O'Malley. Then we will pose questions. For each of the questions, the candidates will have 1.5 minutes to answer the question. The League of Women Voters will continue to keep time. Thank you for doing that. And they will show the candidate a sign for 30 seconds left and stop. When the stop sign comes up, please stop speaking. We will continue to alternate which candidates will answer the questions first. And just like in the first round, the last question will be a speed question with each candidate having just 30 seconds to answer it. And then you'll each have an opportunity to give a closing statement of about 1 minute in duration, starting with Ms. Price. Ms. O'Malley, please provide your opening statement now.
Thank you. Good evening, everyone. My name is Nancy O'Malley, and I'm the district attorney. I've been in the office since 1984. Before I became a lawyer, I worked as a volunteer in a rape crisis center and really witnessed firsthand the injustices that how the system worked, especially for victims, and that's what drove me to law school. When I joined the district attorney's office, I felt very fortunate because it was an office with a stellar reputation that had solid leadership, once led by Earl Warren. And when I entered the DA's office, it was really my intent to change a lot of what I saw was injustice, starting with how victims of crime were treated. And since I've been in the office, I have done a tremendous amount of work in expanding services, including creation of our Family Justice Center, which creates a complete different paradigm of how we're working with victims of domestic violence, sexual assault, human trafficking, elder abuse. And the other area that I put a lot of focus is on working with human trafficking. But from a DA's perspective, the DA has to have heart, and I have heart for victims of crime, of course, but also for those accused of crime. And so we've done a tremendous amount of evolution from when my predecessors were here, but also in creating many collaborative courts and really focusing on how we're going to help improve the lives of people who find themselves in the criminal justice system. And thank you. Please, go ahead.
Okay. So good evening. My name is Pamela Price, and I'm running for District Attorney of Alameda County because I'm a drum major for justice. For 27 years, I've worked as a civil rights attorney in this community, successfully arguing against racial harassment in the United States Supreme Court and creating new laws to stop sexual harassment. I've been a Northern California super lawyer every year since 2003. I've been the California Lawyer of the Year for employment. I've been the Assembly District 18 Woman of the Year, and I've won numerous other awards, including the Clinton Wayne White Trial Advocacy Award twice. I decided to run because we are in a pivotal moment in this country. I'm a survivor of the Ohio juvenile justice and foster care system, and I literally made it to Yale College by the grace of God from the streets of Cincinnati. In this moment, criminal justice reform is at the heart of protecting our democracy and the values that we all hold dear. Criminal justice reform is at the heart of public safety. And so I am going to be a progressive district attorney that will protect public safety by advancing justice in collaboration with our community. Our community is desperate for police accountability, for effective criminal justice reform, and an end to the racial disparities. As the next district attorney, I will create a climate of fairness and transparency and work to improve the administration of justice throughout the county. Thank you.
So thank you both. The first questions and all questions will be directed to both of you. Ms. O'Malley, your responses first regarding your support. What groups and key community figures support you, and why do you think that your supporters are most reflective of the values and priorities of Alameda County?
Very proud to have the support of Senators Kamala Harris and Dianne Feinstein, of several of our other federal legislators. as well as all of our Board of Supervisors, our mayors, most of our city council members, the Sierra Club, the Alameda County Democratic Central Committee, the Labor Council. I'm also endorsed by Thelton Henderson, which makes me very proud, because Thelton Henderson is someone who is an icon of the civil rights movement, who stood with Martin Luther King during the civil rights movement, and it makes me very proud that he recognizes both what I bring to the justice in Alameda County as well as my office. What I think that all of that has to do with me being the person that they are supporting is that I have the experience to run an office of over 400 people, to deal with the complexities that occur in Alameda County. It's a very diverse county, the fourth most diverse in the United States. I also believe that they have seen how much work I've done from my heart, from my experience, from my vision, to really change and to reform or to change the way the criminal justice system is in Alameda County now. Through bail reform, through changing how victims of crime are treated, through the work we've done to around the consumer and environmental protection, that these leaders know my work and know who I am and know where I come from.
Ms. Price?
Sure. I would say I've been endorsed by a wide variety of people in this community. Just today, yesterday, I think we announced the endorsement of former mayor and Congressman, long-term Congressman Ronald V. Dellums. I've been endorsed by the California Nurses Association. I've been endorsed by the International Federation of Union Warehouse and Laborers, ILWU Local 10. I've been endorsed by ATU Local 192. So I've been endorsed by a variety of labor groups. I've been endorsed by many leaders in this community, former Mayor Les Newport, a variety of folks on the Berkeley City Council. I've been endorsed by Vinnie Bacon from the Fremont City Council. I've been endorsed by Karina Lopez of the San Leandro City Council. I've been endorsed by icons of the civil rights movement as well. Angela Davis, Alicia Garza, who's a co-founder of Black Lives Matter, who is an Oakland resident. I've been endorsed by a lot of young activists and organizations that are working on the ground and have been working on the ground for racial justice and criminal justice reform. I've been endorsed by Sean King, the Real Justice PAC, by the Smart Justice PAC, and in a recent poll, I was endorsed by the majority of voters. We were 8 points ahead in the latest poll. Thank you.
Thank you. And Ms. Price, the next question for you first. As the head of an agency with around 150 attorneys, how important is it for elected district attorney to have prior hands-on experience investigating, conducting, and practicing criminal trials or criminal law?
I think it plays a part in it. I mean, I have experienced a lot, not as much as a career prosecutor, but I started my career as a criminal defense lawyer in Bayview Hunters Point Community Defender's Office. My first published opinion, I realized, is a criminal case because I was trained how to do appellate work in the criminal justice system in San Francisco. I was recalling that I tried a case, some of you may not even remember Judge Wilmot Sweeney, who I tried a juvenile case in front of him. I used to practice in front of Judge Horace Wheatley and Judge Ben Travis and do, enough criminal work to understand how the law and the system works. I think that it is, so I think it's important to have some knowledge about it, but ultimately, as we all know, that is not the job. I don't get to try cases, which is what I love to do. I would love to try cases, but I don't get to do that as a district attorney. My job is to set policy, to bring, as I said, criminal justice reform to Alameda County, to look beyond the day-to-day work that the lawyers are doing and give them guidance as to how they exercise their discretion, how to implement the criminal justice reform measures that this county has voted for overwhelmingly since at least 2012. And my job also entails, as the district attorney does, going to Sacramento. I will go there to support criminal justice reform, not oppose it.
Ms. O'Malley?
Thank you. I think it's critically important to have the experience and to have training. have tried 76 cases to verdict as I work my way through the office. There are a lot of different divisions in my office. And I think it's critically important that the person who is setting policy or is leading that office have the experience of what it is to run an office of 400 people. When I took over as district attorney, there were 300 employees. My budget was in the, somewhere in the 58,000. It's now about 59,000 from the county, but I'm able to generate $17 million every year to support the 100 people of the increase of my staff. We're now at 404. And that's because we have vision, we have credibility, we have the trust of funders, as well as the trust of those that are giving grants from the federal government, from Sacramento. This is a critically important way to, ability to be able to balance the safety of our community with the progressive reform that we've implemented, such as bail reform. So our pre-trial population in Alameda County Jail is now about 25%, as opposed to 70% of the state average. We provide services to over 30,000 victims of crime every year. We also have, and it's been very purposeful for me, to make sure that the staff in my office reflects the community. As I said, we're the 4th largest, and my staff reflects that.
Thank you. Ms. O'Malley, next question, regarding details. Particularly in light of recent scientific research and emerging case law regarding the adolescent brain development, what special procedures should be used in assessing how juveniles are prosecuted and or sentenced, particularly in Prop 57 cases?
There are we know a lot more, and this is one of the areas where I think the openness of the district attorney or myself has really helped to evolve around this issue. So we have, with juveniles, that the law changed Prop 57 that requires a fitness hearing. And what that has done is that has prompted social workers and other people to really take an in-depth look at juveniles who have committed serious crimes. And I will tell you that that has really changed the paradigm in my office about how we're looking at juveniles who are committing serious crimes. This year so far, we have not sent one juvenile into the adult court. And last year we had 2 that went to adult court. But there are juveniles, some that are committing some very serious crimes. And in that fitness report, the juvenile justice system tells us whether or not that particular juvenile is fit for the juvenile system. And if they're not, then it's up to the judge to make that determination, whether the juvenile will stay in the juvenile system or not. Since in the last 5 years, we have reduced the filings against juveniles, just filings alone, by 2/3. Last year, there were 400 hearings that occurred. When I took over as DA, there were the average of 1,700 filings that resulted in. So we're doing a lot with juveniles through restorative justice, through girls' court, through mental health court, through getting kids into community courts so that they're not actually coming into the system.
What was the question, please? I'm sorry.
Sure. Particularly in light of recent scientific research and emerging case law regarding the adolescent brain development, what special procedures should be used in assessing how juveniles are prosecuted and or sentenced, particularly in Prop 57 cases?
Well, under my administration, every case will be a Prop 57 cases, if I can say that. Alameda County passed Proposition 57, which was primarily to stop charging juveniles as adults by 77%. So the voters have spoken. We do not want to charge juveniles as adults. The science is also clear. Prior to age 25, juveniles, young people, are simply, their minds and their brains are not fully developed to appreciate the very real consequences, even in the most heinous crimes. Brian Stevenson, in his seminal work called Just Mercy, says none of us want to be judged by the worst thing we've ever done in our lives. And if you think about it, before you get to age 25, you've done some pretty terrible things if you're a normal kid that you didn't even think was, you made mistakes. And so we have to stop taking our juveniles and throwing the key away, which is what we've been doing, and that's why we had to pass Proposition 57. It was directed at the discretion being exercised by district attorneys across this country who were sending juveniles to adult courts. And in fact, between 2010 and 2016 in Alameda County, a black child was 65 times more likely to be charged as an adult than a white child, and a Latino child was 27 times more likely to be charged as an adult than a white child. In 2014, we were one of only 9 counties where the only kids charged as adults were black or brown.
Ms. Price. Now, we have no way of confirming whether this is true or not, so you may have to address it in your response. At a previous DA forum, you both pledged to stop charging juveniles with misdemeanors. What is or would be your timeline to implement this policy?
The first 90 days. We have developed a plan, a series of criminal justice reform measures that we have, one of which is under juvenile justice, is immediately within the first 90 days to stop charging juveniles as adults. We actually will go back and look at those children who are currently charged as adults and in the process of being convicted. Proposition 57 gives every district attorney the power to go back and bring those children out of the adult system back into the juvenile justice system. And we will implement that piece of the policy. It's being done in other counties. It has yet to be done in Alameda County. And I just want to say that according to the district attorney's 2015 report, there were 1,000 petitions filed in juvenile cases and 754 hearings conducted. And at the same time, we had less than 80 juveniles went to the mental health court. I think there were 23 cases that went to the Young Women's Saturday program. Oh, it's 83 cases that were reviewed and the safety plans developed under the safety net program. So we have a huge number of children that are being prosecuted in our juvenile courts and a very small percentage of kids that are actually getting to some alternative dispositions, including no restorative justice. Thank you.
Yes.
Yes, so what we are doing now with juveniles that are committing low-level crimes is we're sending them to community court, and we've got community courts in northern part of the county as well as the southern part of the county. The other thing we are doing is, rather than charge them, that we're doing informal diversion. And I'll just say that the girls' court is, sorry, not girls' court, the Young Women's Saturday program is not for kids who have been involved in the juvenile justice system. The Young Women's Saturday program is a program that I've created to work with young women who have been sexually exploited and trying to get them into a place where they're healing and they're safe. And also with the other court that was referenced, the Safety Net is also not a juvenile justice-based program. Safety Net we put together in January of 2011 because we had so many young people who were being sex trafficked and nobody was checking in with them. So Safety Net really provides safety plans, and it brings all the professionals together in a confidential setting to talk about what we can do with these young people. They're both, are they linked into services? Are they in a safe home? Are they back in school? What are they doing? And that safety plan has been prepared for over 5,000 children since January of 2011 who have been sex trafficked in this county, not people who are caught up in the juvenile justice system. These are programs that are just examples of the way in which we're looking at juveniles differently. And those two examples is how we're looking at juveniles who are victims of crime and doing something innovative and different that's having the effect. And with the other ones are other alternatives to bringing them into juvenile justice.
Ms. O'Malley. Alameda County has a significant number of undocumented immigrants. For those who end up being prosecuted for local offenses, what special procedures, if any, can or have been taken to ensure that federal enforcement officers do not get involved?
Well, we don't work with ICE, we don't work with Homeland Security, we don't work with those federal agencies, and that's critically important. We have a policy on how we deal with somebody who is without documentation that comes into the criminal justice system. And we consider the consequences of them being charged as well as the consequences of them being convicted. If the consequence for, I'll just use driving under the influence, is that they may be deported, that far outweighs the consequence for that crime. So we make adjustments to the charges, and so that we can make sure that people are safe and that they're not going to be unnecessarily engaged by the federal system. One of the things is that we don't always know someone's legal status. We rely on their lawyers to tell us. And I have to say our public defender's office has engaged immigration lawyers who prepare reports for those that have potential immigration issues. And they share that information with us so we can work together to make sure that people are safe here that live amongst us, and people that that we're helping. For those that have become victims of crime, we have the ability, and we do on a regular basis, help them file petitions so that under either have continuous location here. We help victims get T visas for trafficking. We help people get U visas if they're a victim of violent crime. And we talk about that in the community, and particularly at the Family Justice Center.
Yes, so in the winter of this year, we've just gotten through, there was a report prepared called The Prosecutor's Role in the Current Immigration Landscape. And it provides it gives an overview of how the prosecutors have fueled deportation and presented essentially a pipeline from our local criminal justice system through the immigration courts. And it talks about things that prosecutors can do, including establishing the prosecutor's office as a safe haven for immigrants. It talks about making sure that prosecutors are in fact working aggressively with the public defender's office to ensure that the particular charges are not going to result in immigration consequences. It talks about aggressively seeking post-conviction relief, which is certainly warranted in this climate now, because for years we have in fact been providing people with sentencing and convictions that now have consequences, whether they've committed a new offense or not. And so as the next district attorney, I will take the initiative to go back and make sure that we can participate in the efforts to both streamline and expedite people's opportunity to actually be relieved from convictions that have immigration consequences. And even, I mean, these are minor charges that necessarily wouldn't result in incarceration, but that in fact might result in someone being now eligible for deportation.
Thank you, Ms. Price. This question is about implicit bias. Implicit or unconscious biases everywhere. This county has a diverse racial and economic population. What challenges do the prosecutor's office face in this regard, and what safeguards should be employed to identify and eliminate bias in the area of exercising prosecutorial discretion?
As we all know, the prosecutor is the person that decides who gets charged in our community. And I'm here to tell you that based on the Stanford study that has been done in Oakland alone, if you are black in the city of Oakland, you're 4 times more likely to be stopped by the police than a white person. In Alameda County, if you're black, we are less than 12%, 13% of the population. We are 50% of the people on parole or probation and 49% of the people in Santa Rita County Jail. A black person in Alameda County is 20 times more likely to be incarcerated than a white person. That happens because the district attorney is in collaboration with the police, and some of it's implicit, a lot of it is explicit. When the Stanford study looked at the body cams from the Oakland Police Department for 1 year, they found that OPD handcuffed, not even arrested, just handcuffed 193 whites and 2,840 blacks in the same time period. Traffic arrested data was even worse. As a prosecutor, the implications for me is that I cannot charge everybody who gets arrested in Oakland or in Alameda County. I have to look at the constitutionality of every stop. I have to consider whether or not it's appropriate that we bring charges even at that point, or if the charges are being brought, that I will not be overcharging people so that they end up going to jail or having to post bail when they can't afford to.
Thank you. The law has changed in California for law enforcement specifically. They're now required to document every contact they have. And what that's done is it's created a data system. So where a department might have once thought that they were not racially profiling people, they now have data to evaluate and to look at their practices, which allows them to change them. There's a new chief in Oakland, and she's working very hard on addressing the criticisms that came out of the Stanford study, and also to reduce the racial stops, the stops that are based on race in her own department. That's her job, that's the mayor's job, that's the city manager's job. What we did was, in 2015, is that I pulled together a very diverse working group in my office. We call it the Fair and Equitable Policing and Prosecution. And with this group, we went through every single policy, procedure, and practice that we engage in to uncover any implicit bias in the way that we were conducting our business. We did not want to be in a place where we were making decisions based on something other than the facts of the case and what the law said. So we've done that, and we've become very mindful. More than 50% of the cases that come to us are not resulting in charges. And I will say that we are working very hard to reduce the racial disparity. A lot of that is having the leadership in my office of very diverse prosecutors who represent the community. And by having the, thank you.
But please don't sit down so quickly.
Okay.
So now, how would you or do you support victims of human trafficking?
Well, this has been an issue of mine since 1996 when I had a case involving a 12-year-old girl being trafficked by a 39-year-old man. And when the police separated her or got her out of a motel room, she was being raped by a 50-year-old man who had paid to have sex with her. Since that time, I've created several initiatives. The first prosecution unit in the country to have special prosecutors dealing with cases. I've created an initiative called Heat Watch. Heat is human exploitation and trafficking. And it is a 5-pronged blueprint for communities that's been replicated around this country. Training law enforcement, prosecution, and my office has prosecuted almost 600 sex trafficking cases since we initiated in 2005 from Alameda County. That's more than the rest of the state combined. The third prong is making sure we have community-based organizations that are providing services and support for victims. The fourth was we had to change the laws. We had laws that didn't even we didn't even have a law called human trafficking in California until we started working on it. And the last part is engaging the community. So you may have seen some of our billboards. We do a lot of outreach. The billboards, there's no such thing as a child prostitute. They're not Johns, they're child rapists. We've gotten awards for the work that we've done. I also, through an award that I got from the Irvine Foundation that came with money, I started an institute, and we have gone from San Diego up to Shasta County doing public hearings with my commission to really evaluate how the communities are responding to human trafficking. And we also have an Alameda County United Against Human Trafficking, which is now a 50-member strong, that we work together to address these issues.
Thank you. So my involvement in this issue actually goes back to 1977 when I was the first plaintiff in the first sexual harassment lawsuit. And one of our plaintiffs in that case was a rape victim, and that's kind of what propelled us and my involvement in that case. So since that time, I've been an advocate for women who have been not only sexually assaulted, sex trafficked. I've represented numerous victims, including the young woman that was at the heart of the Bay Area police sex trafficking scandal, and that case actually I had to go to Florida to get the young woman. So I'm a person that believes that when victims are in need of advocacy, that you need to be there for them, that you have to be an activist person who is trying to assist them. So I'm not someone that that's looked for awards or looks at people as numbers. I see women as they have truly experienced these things. I also would be an advocate, and have been an advocate in Sacramento, supporting Senator Holly Mitchell, who has done a tremendous job of decriminalizing young women as victims. Senate Bill 1322, which was her work, was pushed forward, and my organization supported that as well. So I have an inherent interest in abolishing sex trafficking. I will not prosecute women as in that area.
Thank you. Ms. Price, newly enacted Rules of Professional Conduct, Rule 5-110, and recent case law reinforce special responsibilities and obligations of prosecutors regarding the disclosure of Brady materials. What steps have you taken or would you take to ensure your deputies adhere to these professional and ethical obligations? And how would you handle situations in which it was alleged that one of your deputies breached these obligations?
As a district attorney, I will take very seriously any violations of the Brady Rule, and I certainly will immediately. That's one of the proposals that we have in the first 90 days. We will implement, initiate, and require an open file policy. If someone is innocent or has exculpatory evidence in a file, it should be disclosed. In the last 4 years in Alameda County, we've had 4 exonerations. People who were kept in cages for years, who it turned out did not commit the crimes that they were convicted of and had to go through a long, drawn-out process to actually get exonerated and to get out. 3 exonerations and 1 conviction overturned just last year, and the court found egregious official misconduct, and my information is that that deputy district attorney is still employed by the office. I think this rule and across the country, we are expecting prosecutors to behave ethically, above board, and to serve justice and not try to get convictions. Prosecutors have been, unfortunately, trained to over-criminalize people and to try to get convictions at the expense of everything else. And that's a metric that under my administration will go away. We will not judge people, or their performance as a deputy will not be judged by how many convictions they get or how many years they sentence somebody to. Their performance will be judged by how involved and engaged they are in the community and how justice is served.
Well, I'm proud to tell you that in my office, that the attorneys that are hired are the attorneys that are the most ethical, the most professional, and that is the standard that we uphold. Ms. Price is wrong about the exonerations. The case that she referenced, the DA was cited for making an argument that was not misconduct. The case was reversed by incompetence of counsel. And so there's a big difference between the defense attorney not doing their job and having a footnote of the DA who made a reference in his argument. But nevertheless, we take this very seriously. I have a public integrity unit. I have a public, integrity conviction unit. So we work very closely with the Innocence Project, if they bring cases to us, and we look at our own cases. We do have a Brady bank. And what that means is that if there's a police officer who's engaged in moral turpitude conduct, whether it's a crime or not, that we're notified by local law enforcement. We have a bank so that whenever that officer's name comes up, we will notify the public defender or the defense attorney of that officer. We notify the court of the officer. And then there's a hearing whether or not the judge is going to allow that information about that officer's personnel record to come out. And I think that's critically important. I'm very proud of the honesty, the ethics, and the high integrity of the people in my office. Some of them are here, people like Terry Wiley and people who are really leading the bar associations, they're leading the community, and they're very much in the fabric of our community. And that makes them, and all of us, perfect for this job, frankly.
Ms. O'Malley. Oh, thank you so much. Do you think special procedures outside of the district attorney's office should be implemented to investigate officer-involved shootings and other uses of force? Should that be the attorney general, a grand jury, or some other body?
Well, the grand jury, the law says the grand jury cannot do officer-involved shootings, and we never did. The Attorney General, there was proposed legislation, and the Attorney General and the legislature, first she opposed it, and the legislature rejected it. The district attorneys are ethical individuals, and they have to be ethical. So we have to be able to make decisions based on cases. We prosecute police officers when they break the law. We also have a team, and there are actually 12 teams, that do an independent investigation of officer-involved shootings or deaths that occur while someone is in custody. They do the evaluation, they do the investigation, and then they look at the law. And right now, there's a bill pending that may change the standard under which a police officer can be charged or under which a police officer can discharge his or her weapon. And we're looking at that legislation. But we are looking at cases every day. And I will tell you that my experience has been when a police officer breaks the law, that other police, good police that are hardworking, that are doing justice every day, are just as rejecting of that officer's behavior as we are. The officer-involved shootings, we prepare a report, it's a public record. In a recent case, it's now a third party is evaluating that case to make sure that someone else is looking at it, that we are above reproach from criticism, which I know there's been a lot, but a third party is looking at it, and they will determine whether or not this shooting was justified. And on occasion, we do ask the Attorney General's office or another agency to look at our findings.
What was the question, please?
Sure. Do you think special procedures outside of the district attorney's office should be implemented to investigate officer-involved shootings or other uses of force? Should that be the Attorney General, a grand jury, or another body?
Yes, I believe that the collaboration and the traditional role between the district attorney's office and law enforcement agencies requires an outside independent investigator. Under my administration, we will establish a new independent unit to address officer-involved shootings, because in Alameda County, since 2005, we've had approximately 127 people die in police custody. We've only had one prosecution of an officer, and that was in the Oscar Grant case. In New York, which is a model, the Attorney General and community groups came together after the murder of Eric Garner. Some of you may be familiar with that. And they actually passed and got the governor to sign an executive order mandating that anytime an unarmed civilian is killed in police custody involving the use of force, that there's an automatic investigation. In 2016, I called for an independent investigation of the sex trafficking ring because 7 different law enforcement jurisdictions were implicated. You have to have independent outside review of these kinds of killings. Public safety requires public trust, and people do not believe that a district attorney's office that relies upon the police and works with the police every day, that hires officers from the police to investigate police shootings, can be fair and impartial.
Ms. Price, we heard from the judicial candidates about the need to see both sides of criminal matters. How are you, or will you, train your staff to consider factors related to the accused as well as the victims?
So my candidacy represents a voice of this community, that we must have balance in our criminal justice system, that we have to stop treating people who may have violated the law, and I say may have, because there is a presumption of innocence the last time I looked at the Constitution. And we cannot assume that everyone who comes into a criminal courtroom has actually committed a crime. And so we have to look at it from the perspective of the presumption of innocence, and we have to balance that with the assertion of the police that they believe that this person has committed a crime. I believe it's high time for a district attorney to take an independent position as a minister of justice and not simply call herself a law enforcement, the top cop or the top law enforcement agent, officer. That is not the role of the lawyer who is elected to serve this community as a district attorney. Your job is to seek justice, representing both the interests of the victims as well as the defendants. That's why we have criminal justice reform, because we're looking for alternatives to incarceration. We're looking to help people who make mistakes to get back on the right track and to give everyone a second chance at a first-class life. That has to be done with a view to serving the entire community and not looking for a conviction or trying to make sure that we fill up our prisons, which is exactly what we've done over the last 30 years.
Well, on a couple of points, my opponent and I agree, and that is that the role of the district attorney's office is to seek justice, not conviction. And that's exactly what the office does. More than 50% of the cases that are presented to us from law enforcement do not result in convictions. And we've also implemented several programs for those individuals who have committed crimes, but we are giving those second chances. One of the community members told me once that I work with very closely, nothing stops a bullet faster than a job. And we took that to heart. So we've got 9 collaborative courts. Courts to deal with veterans with special issues. Courts to deal with young people who are coming into the justice system called mentor diversion. Courts that are early intervention to identify people's needs and be able to direct them into programs that we're funding. We put $20 million a year into the community to be able to help those that have come into the criminal justice system find a different pathway. My office created the Justice Restoration Program. We're the only prosecutor office in the country that is looking at a different way of treating people who have been engaged in crime. So this called Justice Restoration, and it's funded by 3 foundations that are evaluating this new way of doing business to see if it improves the outcome. We believe it will, because we're looking at people as individuals and looking at them holistically. With respect to victims of crime, as I told you earlier, we've provided services to more than 30,000 victims. Part of our job is also to seek restitution, and generally, every year we get restitution orders in excess of $10 million, and that's money that came out of a victim's pocket. So we're very focused and very committed to making sure that we're doing our job to protect victims of crime and to give those individuals a second chance who have been involved in crime.
Thank you. Ms. O'Malley, what changes or reforms should be made with regard to OR, or on recognizance release, or the standardized use of monetary bail, and why are those changes necessary?
Well, we heard earlier from the judicial candidates about how cash bail has been disparately exercised. We have created and adopted a new policy around bail. Our policy is, first of all, we're training law enforcement, reminding them that the law says if you're committed a misdemeanor, that you do not get taken to jail, that you get cited out and given a date to appear. So less than 2% of 3% of those who have committed a misdemeanor crime are actually in custody at their first appearance. We've reduced the felony, the pre-trial felony population in jail to 25%. And those are primarily people who have committed more serious crimes that do pose a threat to the community, charged with murder, sexual assault crimes, serious domestic violence crimes. Those are people that the judge is evaluating that they are a danger to the community. We use risk assessment tools to determine whether someone is a risk to the community. And I think this is critically important. We're working with Senator Hertzberg, who is carrying the bill for bail reform that will transform, not only get away from cash bail, but create pretrial service departments to give the courts more resources so they can look at individuals as individuals to do bail hearings. And it is our written policy now, as it has been for the last year and a half, that we will not oppose someone being released on their own recognizance, and we encourage that we are using risk assessment to make sure people can be released and come back as an out-of-custody individual.
Yes. So we now all should know, if you haven't heard, bail has been deemed unconstitutional, both in California as well as in New York. So our entire country is recognizing the harm that has been caused by the bail schedule, which in California has been a huge driver of pretrial incarceration, pretrial detention that has essentially, as one of the judge candidates talked about, decimated people. They've lost jobs, people have lost their homes, homeless people have lost things, women, the things that they had, women have lost their children. This is the kind of justice that has been meted out in Alameda County over the last 30 years. In 2015, Human Rights Watch did a comprehensive study of bail practices across California, including Alameda County. And they found that in Alameda County, 75% of the county jail population was unsentenced. And they were in there because they could not post bail. In Alameda County, nearly 40% of the people booked into the jail remained in custody until the case was dismissed or they were released with no charges filed. And so what they found was over a 2-year period between 2014 and 2015, we spent $15 million. This county spent $15 million to incarcerate people whose cases were either dismissed or no charges were filed. And why is that? Because we have a district attorney's office that has allowed that to happen. I will not tolerate that kind of mentality.
So now we have what is called the quickie question. You'll have 30 seconds to respond, you in one sentence or thereabouts. And the question is, what specifically differentiates you from your opponent? Ms. Price?
30 seconds. Number one, I will hold bad cops accountable for bad acts. I will not turn a blind eye to police misconduct. If an officer, and I've represented cops and I've sued cops, and I understand that if you're a bad cop, you make the whole force look bad. So I'm not going to tolerate that. Number two, I will work aggressively to eradicate the racial disparities that have decimated communities of color. As a black woman, I am ashamed of the record of racial injustice in this county.
Part of being the district attorney is being able to keep an open mind. I work with a group of men who have all been to prison for and served their time for murder. And we together are creating new initiatives. Having the experience, having the understanding of what the prosecutor's office is, it's a balance. There is violent crime in our community that needs to be addressed. There's also low-level crimes that need to be addressed, but not in the same way. There are victims of crime whose lives are impacted tremendously by crime in their community. And then there's public safety and other issues. My experience makes me very different from my opponent.
Thank you both. Now we will have a short 1-minute closing statement. Ms. Price.
Yeah, I just want to reiterate again that across this country, people are waking up and taking inventory of their district attorney. In Alameda County, we have 79% of us voted yes on Proposition 36 to abolish the 3 strikes law or modify it. 74% voted yes on Proposition 47. 77% voted yes on Proposition 57. Adam Foss, if you don't know him, check him out, Google him. He talks about a prosecutor's new vision of justice, and that if our communities are stronger, they are safer. As we're perceived as one of the most progressive counties in this country. So what we do here matters. Ignoring police misconduct does not make us safer. Turning a blind eye to racial injustice within our criminal justice system does not make us safer. And in fact, prosecuting victims, which we've been known to do, does not make us safer. So Alameda County deserves an ethical, uncompromised district attorney. I am that woman, and I ask for your vote. Thank you.
The way that the district attorney's office was run 50 years ago is different than it is today. The way it was run 15 years ago is different than it is today. Part of what I've been able to do through my vision, through my energy, through my ability to find money to implement and to recruit the right people to carry out the programs really has catapulted Alameda County as a progressive district attorney's office recognized throughout this country. We get awards from the federal government, we get grants, we get recognition. We are held as a national model for progressive DA offices. And the reform that we've been leading in the state is very notable by our legislature, by our governor, by other people in the community. We are moving this state and this country forward. We're part of that group moving this country forward to a new way of handling criminal justice and to looking at public safety and at public safety. That requires experience, it requires a training, it requires the commitment, it also requires the heart. because the people that work in my office come to this job with a heart. We care about our community, we care about uplifting people, we care about empowering people, and that's what we'll continue to do in the next 4 years.
Great. So let's give a round of applause. I want to thank all of you for coming. There is still a little wine and food, and the candidates have materials here on the table. They're all still here, is that right? Yes, they're all still here. So take this opportunity to ask them the questions that didn't get asked. We really appreciate you being here. And thanks for the
All right, thank you for tuning in.
reading materials, MCA materials, candidates.
Oh, phone call.
Thanks for coming, Jason. Thanks for
This way, thank you.
Let me just say goodbye.
I'm Adina, by the way.